Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti. Today's topic is, how does everyone work together? The NAAG Antitrust Task Force and state enforcement. One of the key groups of enforcers in the United States are the state attorney generals. They're explicitly granted authority under the Sherman Act to enforce the federal antitrust laws. And they also have their own independent state laws that they enforce. The thing about them is there are 50 of them. And they're generally trying to achieve the same goals. But to have 50 separate investigations requires some serious herding of cats. Today we're going to talk to one of the leaders of the NAAG Antitrust Task Force, and she's going to explain to us a little bit about how they do that. My co-host today is Anora Wang.
Hi, John.
Hi, Anora. So, Anora, what are we doing today?
Well, today we're going to learn about federal-state interagency work for antitrust enforcement.
And who's our guest?
Well, our guest, Sarah Oxenham Allen, is the chair of the National Association of Attorneys General's Antitrust Task Force and a senior assistant attorney general and an antitrust unit manager at the Virginia AG's office. Sarah has been with the Virginia AG's office for a total of 20 years. And prior to that, she was at the Federal Trade Commission at Bureau of Competition for a total of 8 years.
And what are we hoping to get out of today's program?
We're hoping to learn from Sarah's valuable experience working both at the federal and the state levels, and her experience with the NAAG, which is the National Association of Attorneys General specifically, and how that agency or that association in general works in helping all these agencies work together.
All right, well, let's bring on our guest.
Hi, Sarah.
Hi, Anora. Hi, John.
Hi, Sarah.
Welcome to the show.
Thank you. I'm glad to be here.
So first of all, NAAG, we got to make sure people understand that. What kind of organization is that?
NAAG is an association of the attorneys general of all 50 states, and there are 6 territories. So there are actually 56 AGs in NAAG. The 6 territories are D.C., Puerto Rico, Guam, American Samoa, U.S. Virgin Islands, and Northern Mariana Islands, and all of them have their own AG as well.
Well, antitrust reach far and beyond just the 50 agencies that we know. And then I imagine a lot of coordination would be involved just to have everyone sit together in a room, I guess.
Yes. So we have 2 meetings a year. We have a fall meeting that moves around across the United States. And then we have our spring meeting is the day before the ABA Antitrust Section spring meeting in D.C. every year. And so that's an opportunity for us to meet face-to-face. But we work together all the time. So we have a lot of conference calls. That's great.
And within it, there's an antitrust task force?
Yes. So the antitrust committee of NAAG is the AG level committee. And so the current co-chairs of that committee are Phil Weiser in Colorado, Brian Frosch in Maryland, and Doug Peterson in Nebraska. And then the antitrust task force is the staff level affiliation or committee of the staff lawyers at the AG offices that do antitrust. And so I am the chair of the staff level antitrust task force.
That's great. So I imagine that's a lot of work on top of what you do at Virginia AG's office?
Right. That was one of the conditions of taking the job, is that I still do my actual day job at the Virginia AG's office. But yes, and so internally I head up, plan the agenda and head up the biweekly task force calls where we talk about what's going on with the FTC, what's going on with DOJ, private litigation, Congress, and we also make people aware of new multi-state actions and get committee reports that kind of thing. And then externally, I am the liaison for the states to DOJ, the FTC, the ABA, and other organizations.
So both like internally and externally, there's a lot of coordination.
Yes.
For that to happen. And then I actually thought of a really bad antitrust joke when you said like you're getting together in a room. I was like, is it smoke filled? When AGs. So I imagine if something big is on the horizon, right? And states, I guess the heads of the state AG's office are talking, and then I guess some sort of a coordination in terms of enforcement action. How does that happen? How does that someone initiate? Let's take big company so and so, and then how does that work?
So some of our cases come up through organic. Somebody contacts us, or a committee's been talking about something, and then we start one. Some are started through cooperation with the FTC or DOJ, where for some reason either we drop off from them and go forward on our own, or we continue coordinating with one of the federal agencies. So Suboxone, for instance, is a case where we have a product top investigation. We were coordinating with the FTC, but they got hung up in some discovery disputes, and so we proceeded on our own with a multi-state action against the manufacturer of Suboxone.
Sarah, you sometimes hear from practitioners that why do we need the states? We have the feds. They do just fine. What is it that the states bring?
The states bring a lot of knowledge of local markets and the participants in local markets, so we can be a value add to the federal agencies in cases where there are local market issues. In addition, there are areas where the FTC and DOJ have laid out positions, and then we fill in with more case law and try and develop that area more fully. And then there are areas where, frankly, we disagree, and we have an obligation to our citizens to move forward and protect them in the way that we feel is appropriate under sound economic and antitrust law.
Well, I think those are all very interesting. Let's maybe break that down a little bit.
Sure.
First category you talked about. Can you give us some examples?
All right. So in the Anthem-Cigna merger challenge, there was a national market that was alleged to be harmed by that merger, but there were also several local markets where there was an overlap between the two agencies. Between the two insurers, and Richmond, Virginia, actually my hometown, was one of the most adversely affected, or would have been one of the most adversely affected by the merger. And so there were a lot of witnesses at the trial that were from Richmond, and we helped identify the people who testified, and we were at all the depositions and helped develop the testimony and the case there.
And then how often, I imagine it's working both ways, right? Like the NAAG could be reaching out to the federal agencies, and sometimes I imagine federal agency would be reaching out to help from NAAG, for reasons that you've laid out, like, knowledge of local markets. How does that happen, and how often is that, working both ways, reaching out for help?
So if it's a merger, we usually will, if there is interest among the states to participate with the FTC or DOJ, we will reach out to them, and the interested states will. It's not always a one organic group. It could be, 15 states here, 5 states there, 40 states on another case. It's just a question of which states have the resources and the interest or the overlaps to want to participate in a particular investigation. For conduct investigations, it's a little more idiosyncratic in terms of what we're actually interested in pursuing right now, what we think there's the most reason to be involved.
Sarah, in these coordinated investigations, again, have you ever had the experience where a party will say, well, listen, you're just the states, you stay over there, and we're going to talk to the feds, and we're going to ignore you? Has that ever happened, or has that ever been reported to you, and how'd that go?
It has happened. We do have waivers with the federal agencies, so when they are able to share confidential information with us, and we usually get the information through them. If we're going to be co-plaintiffs, it's not always very productive for us to be shut out of settlement negotiations or other dispositive discussions, because we do have the authority and the ability to bring our own cases or to file Tunney Act comments if we don't agree with a DOJ settlement, for instance.
And are there instances that you decide, like you discuss and then decide this is something that we ought to be taking on our own? And I don't know, we part our ways sometimes. Does that ever happen?
It does happen. We try not to. We try to stay on the same page as the federal agencies as much as we can. I think it's better for consumers and better for us if we do. But there are instances in which that does happen.
Right, yeah. And then, we still remember several, I guess there was a dozen, right, in front of Supreme Court. When was it last year? And then
Amex?
Yeah.
Case? Yes.
Yeah.
Well, DOJ ended up joining in with us after we brought the cert petition in the Supreme Court, granted cert. So they did, but that was an unfortunate decision.
Yeah. So that was one. That was the Amex decision where the states sought certiorari from the Supreme Court, and it was granted, and then the DOJ followed. Basically, this was a case that was originally, I think, brought jointly.
Right. Exactly.
And the DOJ initially decided not to seek cert. The states went ahead and did it, and it moved forward.
Right. We had an adverse decision in the case while DOJ was still involved at the Second Circuit, and they made the decision not to pursue a petition for cert in the states, or most of the states that were involved. Some of the states that were involved decided not to go forward either, but they went forward.
So that's one example. Can you think of another example where the states have gone on separately from the feds?
Well, a recent one was the T-Mobile Sprint merger, where DOJ and the FCC negotiated settlements with T-Mobile and Sprint to allow them to merge. And a group, well, the number of plaintiff states varied a little bit, but it ended up being 13 states plus D.C. That actually went to trial to try and block the merger.
I have in mind another case, and I could have this wrong, but the investigation of generic drugs, I believe, was also one that was initiated by one or more of the states. Am I remembering that correctly?
That is correct. Connecticut is probably the first state that was pursuing that investigation, and we now have over 40 states and 2 different complaints against probably almost all of the manufacturers of generic drugs in the country for price fixing complaints across over 100 drugs. The Department of Justice has pursued criminal antitrust actions against some individuals, and I think they're, it's behind the grand jury, so I'm not sure exactly what they're doing in terms of the companies themselves. But that's one where we're pursuing slightly different areas, so we're complementary to, but not coordinated on that.
And could you give us a sense of how did that investigation grow? I mean, how did it went from being Connecticut to being 40? What was that process like?
So that's what usually happens with a lot of cases is one state or just a small number of states have started looking at something, and if it looks like it's going to be promising or develop into a fuller investigation, they will tell the chair, who is currently me, and I'll bring it up on one of the calls, and people have the opportunity to join if their office grants them permission to join. And that was one where a very large percentage of the states thought it was worthwhile to investigate and then litigate.
Just to break down the considerations that might be involved a little bit, right? So I understand from what we have talked, naturally, there are consumers, some are more locally, some interests are more of a local nature, that's understandable. But something else, like, it depends on, which agents, which state we're talking about. They might be standing, and at which time. They might be standing a little differently on the political spectrum. And then state antitrust law is not always the same, right? So some of that, just the legal, the codes are different, and then where they stand are a little different. And maybe cost, right, could be expensive. Is it really a good thing for this particular? It's just something that I imagine, but maybe you can help us break that down a little bit.
So there are situations where there's one obvious one is there's no overlaps in a particular state. So they would probably choose not to use their limited people resources and their limited monetary resources to join that investigation. There are when it comes to pharmaceutical drugs and insurance, pharmaceutical drugs in particular, states are very large purchasers of pharmaceutical drugs, so we're very interested in activity that increases the price of drugs to our citizens and to our agencies. There are other interests. So the political issues are definitely there for the AGs themselves.
Right.
But in terms of the Antitrust Task Force, we're all career attorneys. I personally worked for both Republican and Democratic AGs, so we try and keep it out of what we do.
The federal agencies themselves often, well, I don't say often, occasionally do not agree 100%.
Right.
How do you manage that? Because you now have probably 58 separate decision makers, right? You'll have a DOJ, you'll have an FTC, and then you'll have your 56 attorneys general.
Right.
How do you manage that?
Very carefully. No, it's tough because there are states that want to get involved in some issues more than others. We deliberately didn't weigh in on Qualcomm, the Qualcomm case, because of the disagreement between DOJ and the FTC. So we try and stay out of hot button issues as much as we can. That's not always possible, but and sometimes things break out along political affiliation when you don't really expect it. For instance, the states have submitted a couple of sign-on letters or comments to the FTC on labor issues. And so far, we've only had Democratic AGs that have signed on to those comments. And that's one where we're not having a political discussion. It's just maybe more of a feeling for those type of issues in one political party than the other right now.
And substantively, as I alluded to a little bit, so state antitrust law is not always the same. Does NAAG do anything, try to bring them, like, converge a little bit, like some, I'm not sure best practice is the right word for it, but to get more agreement substantively?
I think that's the purpose of the Antitrust Task Force, because we work together so often, is to just keep the lines of communication open, be able to be the place where we can air differences and talk about issues and if we need to. But we usually get along very well at our level. So,
Sarah, I will use the term best practices here. What are some of the best practices if you are a defendant? Let's start with if you are a defendant facing a multi-state and combined federal investigation. What are some of the best practices in terms of thinking about making sure the states, you stay on track with the states?
I think going back to something you said earlier is not trying to cordon the states off. Keeping us informed and involved is probably the best way to ensure that we don't diverge from the federal agencies at all. Keeping, not trying to settle with one state at a time is also probably a good way to it sometimes works, unfortunately, but it also alienates you from the rest of the states that are involved. And just treating us as an equal partner to the federal agencies goes a long way.
But I can't help but think there might be some strategic value in talking to some states first, and then kind of like in a settlement, right? You want to line up the order of the talks.
Right. So there are, for every multi-state, there is an executive committee. Mm-hmm. And the states that are on the executive committee vary from case to case. Mm-hmm. And so definitely talking to the states that are on the executive committee is probably fruitful, because they're going to communicate it back to everyone else. Mm-hmm. You don't want to have to go around to 40 different states and have 40 different meetings, but you can have 3 meetings or 4 meetings with the 3 or 4 states that are on the exec committee, and that's helpful.
All right, now let's talk about multi-state investigations. No Fed involved. Anything you would do differently
than what the feds do?
No, what I mean is anything as a defendant that you might do differently if you're facing just a multi-state investigation as opposed to a multi-state plus federal.
Mm-hmm. I can't think of anything that you would do differently. I think that, we try and we work with the federal agencies enough that we have a good feeling for how they conduct their investigations, and I think there's usually an effort for us to do it the same way. We're not bound by the horizontal merger guidelines, but yet we try and conduct merger investigations using the same analytical framework. And so I don't see a big difference.
Is there a sense of competition? Like, with, we states, we're going to do better with than the feds this time. Does that ever happen?
I don't think it's a sense of competition. I think it's just a sense of we should be taken seriously, and we're not necessarily an inferior enforcement branch than the feds are.
Right. Because I brought this up because sometimes I hear the argument that the reason to have Fed and state, like both levels, and also have like multiple state agency and with their different laws, and we're not so concerned with that because there is a very nice competition in that, right? There are like 50 independent experiments basically going on, and then sometimes best practice can be applied there, and then sometimes, it's just different. And then that's the argument that I hear often, and so I wonder if that's the view that the states themselves also take.
Yes, I think Congress set this up intentionally. I've heard people, especially recently, say that this was not the intended way that antitrust enforcement was supposed to work, but yet I think that Congress and the Supreme Court have repeatedly agreed that the states should have the right to pursue these things separately. And, we have the right to pursue attorney's fees for merger investigations under the Clayton Act, and the federal agencies don't. And I think that's a way to encourage us to be proactive in enforcement.
Now let's pretend I'm a complainant, and I have something that I think an antitrust enforcer should know about.
Right.
Are there, if I take it to I think most people would take it to the feds first. Mm-hmm. If I'm turned down by the feds, is there a way for me to get either in front of the NAAG committee or go to individual states?
Yes. So I get this fairly often, is people will call me as the chair and try and pitch a case to me, and I will often set up a phone call where that person or company can make a presentation to as many states as want to dial in, and then we will take it from there and see if we have the resources and the interest to pursue something. There's also, you can contact the co-chairs of our different subject matter committees, like the Labor Committee or the Technology Industry Working Group or the Pharmaceutical Working Group, and pitch it through them.
That's great.
And Sarah, what do you see coming? Look into your crystal ball. What do you see coming with the states in, let's say, the next couple of years? Anything changing? Anything exciting?
I think we'll have an increased focus in the technology area, as are the feds. That's an important issue, obviously, to all of our states, since we have 50-plus AGs on both our Google and Facebook investigations. I think we'll continue to be interested in pharmaceutical issues because of our state purchasers being such big purchasers of those. And labor seems to be an increasing area where we have some interest.
And by labor, we hear about no poach. Is that what you mean, or are there other things as well?
No poach and non-competes are big, but also we're increasingly looking at labor as an input in merger investigations and whether or not that needs to be considered in a different way.
So let's shift gears a little bit. Sarah, you obviously love practicing competition law. Why? What's fun?
I've been doing this almost 30 years now, and I think it's really interesting that every case is so different. You get to learn about different industries and how they work. And I once did a merger investigation when I was at the Federal Trade Commission of kiln furniture, which is what things sit on when they go through the kiln to make toilets and sinks. So that was very interesting. Something I would not have learned but for being at the FTC. And so, and the law in conduct cases is very different from case to case, although the law in merger cases is the same pretty much from case to case, but it's always something different.
And what advice would you give to a younger lawyer who wanted to get involved in antitrust law? What would you tell them to do?
Two things, I think. One is to study economics if you have a chance. That is very helpful in all antitrust cases. I think the other thing is I took 3 years off in between undergrad and law school. I call those my lost years. I had fun during that time, and I think that's really important sometimes not to have your head down and just go straight from high school to college and straight from college to law school and develop yourself.
All right. Now, this is the hardest question we're going to ask you. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, I'm a big movie buff, and I try and see a movie, at least one movie a week. I'm a patron of the Virginia Film Festival and go to that every year. And I try and see all the movies that are nominated for Oscars, even in the little categories.
Did you see Parasite?
I loved, that was my favorite movie of the year this year. And I even saw all of the live action shorts, although I couldn't see all the other ones. So,
all right, well, let's go to our final segment, which we call The Curious Hat.
And now it's time for The Curious Hat.
In an actual hat, I have actual questions, and Sarah's going to choose a question from the hat. We'll ask her that question, and we'll see what happens. Okay, she has chosen question number 19, which is, what is your favorite cuisine?
Ooh. My family is a big Thai cuisine family, so we end up going out to Thai food a lot. I actually kind of like French food as well. I love crepes.
Who doesn't love crepes? Right. Now, where is the best place in Richmond to get Thai food and crepes? Maybe not at the same place.
Not at the same place. The Thai Diner has 2 locations in Richmond. It's very, very good. And I am a big fan of the Magic Pan, which was a chain that used to do crepes, but has sadly gone by the wayside. So
if you're going to go to a movie, Thai or crepes?
I think Thai is a better pre-movie food.
Thai then movie.
Right.
And crepes is more like if you have a big breakfast.
Right. Yeah, or an after-dinner a sweet crepe.
Okay, and with that, we come to the end of another episode of Our Curious Amalgam. We'll see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.